Well, hello everyone. Um, this is JJ Richa with Pismo Ventures, and we're going to wait a minute or so to get everyone chiming in. Um, Hold on, I need to turn this off. We have with us today great guest speakers, including Kwame Ulmer. And then we lost we lost Ken for a second. Thank you, Kwame, for being here. Quan, a repeat guest with anti-IP law. Um, and then Ken August, who's coming right
Here
back.
I am.
Here's Ken. And Ken is with Ken August Law Group, which is a corporate law firm. And Kwame will tell us a little bit about him and his firm when we get started. So we will wait a little bit before we get there. Um, you can join us today. You can join us on LinkedIn Live. You can join us on YouTube. And the link for YouTube is also in the LinkedIn Live event. And then also you can join us on Instagram. First time trying Instagram, so we'll see how that works. And so I don't know how it looks because I'll have too many things going on my screen if I want to turn on Instagram too. So there you go. All right, maybe we'll leave another 30 seconds and we'll get started. Okay, Kwame, maybe we'll start with you. Maybe you could tell us about yourself and tell us about your firm and what you do for startups, especially when it comes to FDA, because I know that's your background.
Yeah, absolutely, JJ. And thanks again for having me. Uh, so, MedTech Impact Partners is a regulatory strategy consulting firm. I was fortunate enough to found it 7 years ago. And between myself and other members of the team, we have combined experience totaling nearly 50 years. And we've been able to work with over 50 companies to help them navigate the FDA. And what does that look like for us? We help develop and draft comprehensive and concrete regulatory strategies, guide companies through the FDA in a pre-submission process, and oversee marketing applications. I've been fortunate enough to work in the regulatory space for 22 years, and it's a joy and delight to work with a range of companies. And we'll talk about, to some extent, those interactions today.
That's great. Thank you very much. Uh, Quan, tell us a little bit about you and what your firm does.
Sure. Great to be here, guys. My name is Quan Nguyen. I'm a patent attorney. Been practicing patent law for around 25 years, a long time, despite my youthful look. Um, a third of our work is to support startup companies, and we really enjoy working with all of you out there who are startup companies. And our work ranges anywhere from drafting patent applications to patentability studies to due diligence on freedom to operate. And happy to answer questions you guys have today.
Thank you very much. Ken, tell us a little bit about you.
Yes, hi everybody, and thank you, JJ, again for organizing these podcasts. I'm Ken August, and August Law Group is a corporate and transactional law firm. I've been involved with corporate transactions for over 30 years. And it's everything from the formation of companies, putting collaborations together, the capital table, the capital raise, and the mergers and acquisitions. And we do a lot of licensing and general corporate and commercial work as well. And we do have a specialty in cross-border transactions. So companies looking to open up emerging markets overseas or foreign companies coming into the United States.
Thank you very much, Ken. I have multiple windows open, so I might be looking right and left here, but it's just to make sure I get everyone and I'm able to answer their questions. All right, so we'll get started a little bit with Kwame. Kwame, I'm going to ask you a couple of questions specifically about FDA. We'll start with you to help us really understand the world of the FDA, since you were so involved in it for so many years. Can you maybe give us what are the considerations when you apply for breakthrough designation? And tell us what is a breakthrough designation?
Thanks, JJ. So a breakthrough designation is the official opinion of the FDA that your product is unique such that it would have a transformative, significant impact on a particular patient population compared to everything else on the market. So what does that look like in practice? You have improved accuracy that's clinically meaningful for a diagnostic and all the other competitors in the space. Or you're diagnosing a new patient population that has no alternatives that are reasonable. And the examples go on and on and on. And on top of that, there's some pending rules under the acronym TSET that may guarantee reimbursement after you get the breakthrough designation and the marketing approval, which typically is what's called a de novo. So you want breakthrough designation to say to the world that you are clearly breaking new ground, you're treating new patient populations in clinically meaningful ways, or more recently, an additional category is you're addressing health equity in some meaningful way. And on top of that, to investors, you signal to them that you have a path to monetization via guaranteed reimbursement if this rule goes through. So that's why companies consider breakthrough designation.
Wow, very interesting. I did not know that, that's for sure. Quan, you can't ask questions. Go ahead, Quan.
By the way, Kwame is our firm's go-to person for FDA matters. He is the FDA insider. Kwame, got a question for you. What are the implications of being designated as a breakthrough technology? Does that mean that you get to sail through the regulatory process faster, et cetera? What are the implications?
Well, you'll get added resources from the FDA connected specifically with your application. And what that looks like specifically is you're available, you have access to experts that will take you through sprints, these meetings to discuss specific topics that are needed for your marketing application. So in theory, you go through these sprints. For example, a sprint on the preclinical data needed for the FDA de novo application, a sprint on the clinical data needed, a sprint on the statistical design of your clinical study. And after you finish all those sprints, theoretically, your application should be quicker, more efficient, and ideally, you can get to market faster.
So does that mean that you get mentorship through the process with them coaching you more so, hands-on more so than the regular process?
That's a really interesting word, Quan. I've never used the word mentorship, but I would replace it with hands-on, above average attention. So
Yeah.
you will get access to the scientists, engineers, and regulators that are going to be with you from beginning to FDA de novo.
So would you say that it would cut down with a sprint? It suggests going faster. It would cut it down from, let's say, 100% as being the normal time to 90% time, 80% time. On the average, what range are we looking at? 50%?
Right.
What are we looking
Well,
at?
I actually can't say that necessarily. And here's a little little dirty secret that going through the breakthrough will automatically result in a reduction in time. But if it were, Quan, it would be that you have the most efficient clinical study that have shaved off, it could be north of $1 million in savings because you went from, let's just say, 6 weeks of follow-up, you negotiated to 4 weeks of follow-up. And that is the big advantage of going through breakthrough. You get the right clinical study that probably could be less than if you had gone through the normal process. And that in and of itself can save you time and money.
My last question within the next 5 minutes, I promise.
Yep.
What are the things that you have to do to prove that you're a breakthrough? Do you have to publish in Nature, in Science? What is the qualification? Who's going to make this determination?
Quan, these are great. The check is in the mail, Quan. These are great questions. So you actually, on paper, all you have to do is answer about 4 questions that the FDA puts before you to confirm that you really are treating a new patient population or have outsized clinical outcomes. But in practice, what you really need is some preliminary clinical data to show safety and some initial qualitative sense that you will clinically have better outcomes than standard of care and any other alternatives that are out there.
So, Kwame, if I had a client that felt that they had something that would qualify, how do they interact with you? What's your part in the process?
Thank you, Ken. I actually look at their indication statement, the device description, and the claims they want to make, and any initial clinical data. We're working with a client that has data from China, and we give them a recommendation. We provide a formal regulatory memo, a strategy that answers the question, are you a good candidate for breakthrough? And we will be a guide and a thought partner with them through the actual application process and make sure that it's as strong as possible. Thank you, Ken.
Thank you.
Thank you, Kwame. That's very important information. Definitely, I didn't know, as usual. It's just since this is not my world, so of course. Please, I'm gonna ask everybody to ask your questions. Like I just put in the chat, we have a lot of people online. We're on LinkedIn Live on my personal LinkedIn, JJ Richa, and then it's also on Pismo Ventures, and also on Instagram, and also on YouTube. So ask questions anywhere. We have a lot of people here, so please don't hesitate to ask any questions. I have another question for you. What are good reasons to meet with the FDA?
So number one, you can share with investors a granular, detailed timeline for when you expect to get market clearance or de novo granting. And that can be a value inflection point of millions of dollars from the eyes of investors. Number two, you also can confirm with your marketing and sales team the types of claims that are within bounds and out of bounds because you've met with the FDA. And the list goes on and on. I wrote 10 reasons why you want to meet with the FDA, but those are 2. And the last, which is normally the number one reason companies want to meet with the FDA, is you get confirmation of the exact clinical study that you need to do for your marketing application. And you can price that. You can get quotes from CROs, and you can also back into potential animal and preclinical data. And you have also, this is the bonus, get insight and confirmation of all the guidances and standards that you need to adhere to for your product. So it's your tax dollars at work, quite candidly. That's my running joke. But you have this free mechanism to get the list of all the data you need to get collected for your marketing application.
All right. We have one question in the chat for you. You just answered it, so they wrote back, never mind, it was just answered. So there you go. How about that? Okay. I'll switch to Ken for a second. There's some new stuff, Ken, that are going on in the marketplace that could be potentially could hurt companies if they don't comply with it, and that is the new Transparency Act. Um, so maybe you could tell us a little bit about that, and maybe what kind of penalties are potentially companies could be hit with, and when do they need to comply with with the Transparency Act?
No, that's a great question, JJ. Thank you. So the Corporate Transparency Act came into effect on January 1st of this year. And it's part of the government's anti-money laundering and other types of laws that are designed to try to understand the corporate relationships among different entities that have been formed in the United States. Basically, the rule now is that if you are an owner of an equity interest in any entity that has been formed through a filing with a Secretary of State in any of the states. So that would be all corporations, all limited liability companies, all limited partnerships. If you have an interest in any of those, then the company, the issuer itself, is required to file with CINFEN, which is an agency under the Department of the Treasury. There's a filing that needs to be made to give information on all of the beneficial owners of that entity. And the beneficial owners are the equity owners. And if there are entities that own equity, those equity owners, all the way up the chain to the top individuals in the chain. That information has to be filed. The timing of it depends upon when your entity came into formation, but the rule going forward is going to be that you pretty much have to file it almost instantaneously after it's formed. And the filer has to have, it can be an attorney, it can be somebody from the company, it can be a CPA, but the filer has to be pre-registered with CINFEN with a number to be able to make the filing, which is done electronically online. Much like if you were filing a Form D with the SEC, similar kind of a process. The consequences, though, are draconian. If you fail to file, you can end up with very hefty financial penalties as fines, and if it's willful and continuous, there even can be jail time. And so we want to make sure that everybody files. And the thing that's so interesting about this regulation is it doesn't matter if you only have one entity, so single member LLCs or single shareholder corporations have to file, even if they've not made revenue, even if they have no employees, even if they've not filed a tax return, you must file with CINFEN.
Okay. That's and the penalties, like you said, there's financial and potentially jail, especially for repeat abusers.
Correct. For the real willful failures to file.
Yeah.
And I do, my email address is on the screen here. I do have some further information I can provide to people. Would be happy to if you email me. It's a free paper about that.
Yeah, please go ahead. Don't hesitate to to reach out to Ken. I have a question from Greg. Greg, yes, there is a website. I have it. If you have it, Ken, you can type the website for FinCEN in there, or I can type. Oh, someone just typed it in there. That is the correct website. So thank you for doing that. I will also post it on the other channels while this is being, but I'll show it on the screen. This is the website for FinCEN. It's boiefiling.fincen.gov.
That's right. And BOI stands for Beneficial Ownership Interest, which is the specific equity ownership of individuals that they're looking for.
Thank you so much, Terry. Much appreciated. Again, if you have any questions for Ken, feel free to email him. His email is on the screen. One question, Ken, is what level of ownership in a C corp have to report?
All of the shareholders of the C corp, and if the shareholders are themselves entities, then all of the shareholders of those entities until you get to the top layer of individuals.
So everybody, one or more or any, everybody.
That's right. And it doesn't matter if they're foreign or domestic here in the United States, everybody has to report.
All right. Thank you, Ken. Any questions for Ken? Please, you can still pose it right now. Meanwhile, I will go. Oh,
I think
Quan has a question again. Okay, Quan, go for it.
Well, I'm an impressionable mind. I love learning. What can I say? So Ken, two things. One is that seems to me that investors, even major investors into a company, do not have to report. Is that correct?
No, investors have to report.
Investors.
Yeah, everybody, if they have an equity ownership in a company, they have to report all the way up to their beneficial owners. There are some 23 exemptions, but most of the exemptions are for companies that are already regulated and providing the information that FinCEN is looking for. So if you're a public company and your stock is trading on an exchange, you're exempt, and other large corporations with large numbers of shareholders are potentially exempt. But you really need to go over those exemptions with an attorney, because if you make a mistake, as we've said, the consequences for failing to file are great.
So just walk me through the concrete example of this. Company pitches, company presents at a, let's say, CxOs Angels. I invest. Beginning when, what time frame, and what triggering point do I need to report?
So the company, in order to make the presentation, was already formed beforehand. They had an obligation to report and make the initial filing at the time that they were formed. Every time there's a change in the cap table, every time new equity is issued, whether it's to an investor, whether it's sweat equity given to individuals in exchange for services, whether it's in the context of a merger and acquisition or in the context of a joint venture, every new issuance of shares on the cap table requires an updating filing. And there's not a requirement to file every year if there have been no changes, but there is a requirement to file every time there is a change.
So then the startup would do the filing, but me as an investor, what do I have to do?
Well, you don't have to do anything. You're not responsible to file to FinCEN. It's the company that has to file to reflect that they've issued you shares for your investment.
Good. So scratch off that to do. Good.
Right.
Good.
But if it's a public company and you make an investment that's a significant investment, then you may have forms that have to be filed with the SEC.
Got it. Thank you, Ken.
Sure.
Well, thank you, Ken, very much. We'll switch to, now we'll ask a Quan question. Why not? Right? So
you want me to ask myself, since I've been asking questions of everybody? I was just
no. Then I don't do anything. So all right. So we'll switch to you. And one question is, what would be the benefit of keeping innovation and innovation trade secret versus filing a patent application?
Sure. Great question. Thank you, JJ. So trade secrets are meant to be kept in-house, not for anybody to see. And the benefit of that is that others can't leverage off of what you've discovered and make it better and compete with you. Filing a patent application, let's say that you are successful in securing a patent on that, you have the right to stop others from doing what your patent calls out. And the thing is, though, your invention is public to the world. The world, your competitors can look at what you do, and they can use it as a stepping stone to do better things than you, or to do exactly what you do and then try to compete with you in ways that you're going to have to fight them. So there are benefits to keeping a trade secret, just to leave it out of the public domain altogether, and no one would know, and they're going to have a hard time trying to compete with you. The the downside of the trade secrets are as follows. Number one is, if your trade secret can be reverse engineered, if they can pull it apart. If you have a widget, it's clear. They'll look at it and they'll see what it is. There's no way you have a trade secret on that. If you have a polymer or some formulation, there are ways to getting to it. So the question of the trade secret of Coca-Cola, can you reverse engineer that? And a few other things as well. If you can reverse engineer, and you would know because it is your industry, it is your technology, and you're the expert on it, you would know if something like this could be reverse engineered. If it's reverse engineered, and you have a trade secret on it, someone else reverse engineered it out there, and they start doing it, they start putting on internet. Now everybody knows there's nothing you can do about it. At that point, if the trade secret is your company and the lifeblood of your revenue, that's it. That's the end of things. Okay. So then that's the first question you want to ask is it something that could be reverse engineered easily? All right. So then the following of the patent, as I was mentioning earlier, is that it's for the public to see. But the thing with the trade secret is, the thing with a patent is that you have something in documentation. If someone tries to compete with you and they can prove that they do what you do, then you can go after them, and you can send them cease and desist, and then escalate if they don't comply and sue them in force. And you do have the backing of your patent to stop them. There's something that you can do about that in the wide open, in public. Now, contrast that with trade secret. You have to keep it tight. Once it's breached, there's nothing you can do. Now, there are situations where a trade secret could be backed up by an insurance policy. And what I mean is this. So you can have your cake and eat it too. You can maintain something a trade secret, and at the same time making sure that in the event of breach, in the event that someone reverse engineers it or something like that, you have an insurance policy on that. That insurance policy is a secretly filed patent application. Let me explain that a little bit more. When you file a patent application, automatically it becomes published after 18 months for the world to see. There's a little tiny box, little line that says do not publish. When you first file the patent application, if you check that box, then the patent application will never publish. It would be underwater or under the current, and no one will ever see it. Now, you can maintain that application in parallel with your trade secret. Patent applications or patent terms are for 20 years. So if you want to put up with it for 20 years, there would be some costs that are involved with upkeeping, but no one will ever see that patent application. All the meanwhile, you're practicing your trade secret that no one ever sees either. In the event that someone does what you do, or in the event that someone breaches your trade secret, you can always activate that secret patent application to granting. And again, it does take some prosecution and all that stuff, but let's say that you have that. So that's the insurance policy, is that you file your secret patent application. If your trade secret is bust open, then you can rely on your secret patent application and go after the competitors for that. Right? So that's the pros and cons of trade secret, pros and cons of patent filings, and the interplay of how you can utilize the two together.
I have a couple follow-up questions, Quan. Mm-hmm. If you go that route of filing the secret application, and then at some point somebody comes out and you activate it, what is the duration of the patent that files? Does it start on the date you activate it, or does it relate back to the original application date?
Once upon a time, it's on the date that you activate or granting, but these days it's 20 years from the date that you filed your patent application. So you can, if you maintain it for 10 years, a secret, and then you activate and you get granting, then you have 10 years after that. It's a little bit more complicated, but altogether 20 years only. But 20 years, that's pretty good.
Yeah, no, it's good. So, and then once the application becomes public, if somebody from another jurisdiction finds it and they attempt to file that patent in their jurisdiction, is there anything that the US patent holder can do about that?
So a couple things. One is, you're right, the patents are jurisdictional, US, Canada, Europe, so on and so forth. By the way, guys, UK broke off from the European Union, but in the patent system, they're still part of it. So just as an aside, so patents are jurisdictional. When a patent application is filed, a correct inventor has to be identified, meaning that they have to invent that thing. So they simply take something from afar. I get that asked this all the time. Can I take something from the United States and file it in China or the other way around, things like that? Well, the first barrier is you got to show that you got to prove that you're the inventor. That's number one. Secondly is that if something has been in the public domain, then let's say the traditional run is this, something like this. You file something in the United States and it gets published, right? It gets published here in the United States for a day or two or even, longer than that. So in China, can they pick up on the publication of the United States to actually file a patent application over there? The answer is no, because the United States becomes a prior art against the China. So although patents are jurisdictional, the prior art is globally used. Anywhere on earth at all, if there is something that already exists, then that particular jurisdiction cannot file a patent application, cannot file patent protection on that because it existed somewhere else in the world. But once that jurisdiction, once the inventor gets a patent in that jurisdiction, the protection is only within that jurisdiction.
Thank you.
Yeah. Wow. Well, I guess if I have any more questions, I got to call you and ask you questions that are very specific, because there seems to be a lot of things that could go wrong if you don't know what you're doing. I'm going to switch back to Kwame unless we have more questions for Quan. Okay. Here's Kwame. Kwame, tell us, what is IRB and what are the do's and don'ts of IRB?
So IRB stands for Institutional Review Board. And when you, as an innovator, entrepreneur, and I think that's most of the participants, want to use a device outside of what it's been cleared by the FDA to be used for, or there is no clearance, or FDA de novo or PMA, these are all approvals by the FDA to market your device. Before that, you go before an independent body and make the case that you're going to ensure reasonable safety for patients in a study. It could be an observational study. It could be a randomized control study. It could be somewhere in between. But you are meeting with an institution that is trained to evaluate not only the safety, but the ethics of using this product, this device on humans. From there, that approval will give you what you need to actually start a study at 1, 2, 10 sites, clinical sites. And there are IRBs that are associated with academic institutions, and there are IRBs that are for-profit. Either way, you have to provide an application which describes the indication you want to treat, the protocol you want to study patients under, the endpoint, safety and effectiveness, the overall study size, how many patients do you want to study, and all that. And I'm going to anticipate your question. For the FDA, needs to be conducted according to what's called good clinical practices. So you have the proper safeguards in place to make sure that the patient is well informed, to make sure that you're properly collecting data, and have stopping rules if there was an adverse event or a series of adverse events. All of those are principles under good clinical practices that go beyond an IRB and would be needed for the FDA. But step one is put together an application to this IRB. There are for-profit and one associated with universities, and then you go from there. Yes, Quan.
It sounds to me,
Yeah.
I will let you ask Quan, no problem. It sounds to me that everything potentially related to the FDA, IRB, and everything you talked about, breakthrough, I mean, it seems like so well integrated with potentially someone needs to file a patent because it needs to be somewhat protected to some extent. Does that make sense? Like you have to kind of do both at the same time.
Well,
Yeah, that's a fascinating topic, JJ, and I'll touch on that. So here's one in the nutraceutical sciences, for example. First of all, there are two entities, FDA and the patent office. I wonder though which agency actually makes more money. I know for the patent office, they are so cash positive because of all the requirements of fees after fees after fees, and the folklore is that they're so cash positive that they actually use their surplus to pay for all the other agencies. I don't know how cash plush the FDA is, but I'm sure they are as well. So they're two separate agencies. First of all, when you file a patent application, the language is very, very different from the FDA language. And sometimes you have to one has to be careful, because even though it's for patenting, if one says something in the patent and it contradicts what something represents in the FDA, it is possible that the FDA can point to it, and Quan can know about this. But I would imagine that it is possible that the FDA can point to the patent and say, "Well, you said this. You said that you can do this, that, and the other," which is a tension, because in patents it's a forward-looking thing. There's no requirement for data to prove that you've done something, but you can always proactively claim something in the future as long as you enable it, and so on and so forth. So that could be at a tension with the FDA. In the nutrapharmaceutical space, and we have to tread very carefully with this, is and I like to Kwame to speak to that a little bit. Actually, there is no FDA requirement. This is one of those things that like herbs and things like that, where you can have clinical benefits, but at the same time you don't have to go through FDA. In the in the patents though, when we write that it does certain things and so on and so forth, we have to be very careful to stay within the parameter of what it is that is said for the FDA. Because I don't know if you've seen this on TV, a lot of nutraceutical companies, they would actually advertise, we have 5 patents, and then, well, those are the numbers. Well, people go to it and they read it, and if the patents say these things, I would imagine, and Kwame, please clarify on this, I would imagine the FDA can actually call that out as being false advertising, or whatever the term is, that is not compliant, because they expand on more of what the indications are, the treatments are, than what is within the parameters of avoiding the FDA scrutiny for regulation. So that's one. The other actual real intersection between the two is this. Ken asked the question earlier, patent term. Okay, it's 20 years upon the filing of your non-provisional application. It's that specific. There are other things that affects it. There's also this thing that's called a patent term adjustment. So the one thing for sure, there are several bases for adjusting or increasing beyond that 20 years. One is that when the patent office communicates with you, you turn something in, they have so many days to get back with you. If they miss a day, you get an extra day. If they miss a week, you get an extra week. Tag on to the end of your 20 years. Also, FDA approval takes a lot of time. And this would take years, 1 year, 2 years, 3 years, 4 years, 5 years. The time that you can prove that it was at the FDA for approval, you can actually take that time and tag it onto the end of your 20 years. Now, if it's a blockbuster molecule or drug, one day could be millions, tens of millions, hundreds of millions of dollars. Those things matter. So that's the interplay between the FDA and
that's a huge intersection.
Yeah, That is, and we often do this. Here's the interesting dynamic between a startup and a mature company. Startups, for the most part, when they file a patent application, they usually just want to get a patent so that way they can check a box for the investors, say, I have a patent. And it's important at the beginning. But, most of the startup companies, their intention is to get acquired and leave after 5 years, 7 years. It is the acquisition entity that is interested in the longevity of it. Because towards the end there, so you have drugs like Prilosec. Oh, goodness gracious, the story of that. This is the purple pill, the antacid thing, purple pill. There were trucks and trucks and trucks of these Prilosec generics that are ready to go on the day of expiration of the Prilosec patent some, 15 years ago. But anywho, so that's the intersection between the FDA and the patent office. Pretty cool stuff.
All right, Kwame, feel free to chime in.
I was just going to say, while it is absolutely a check in the box, we often meet companies after they've gotten a provisional patent or done some IP work, and they can, at a minimum, describe the product, because that's the basis for developing a regulatory strategy and knowing whether you're regulated as a 510K or a PMA. And there are, if you have a good FDA lawyer or IP lawyer, IP protections for PMA devices. So the only thing I want to say is, yes, there are a handful of disciplines outside of just R&D and clinical that are there at the early stages of a medical device company. IP is one of them, regulatory is another, quality is another, and they all kind of interplay.
Thanks, Kwame. Ken, maybe since both Quan and Kwame talked about this, when it comes to potential exit, you should have your ducks in a row as far as your corporate, legal, cap table, everything in place. So when that exit happens, you're not leaving a lot of money on the table.
Yeah, there's no question about that. I mean, the due diligence, and not just an exit, but a significant investor round. Any time there's going to be even a public filing with the SEC, you have to have that done. And it raises an interesting question, which I'll throw back to Quan, which is, if I'm showing my investors my IP portfolio and giving them an opportunity to examine patent and patent applications and other IP, which I hold confidential, is there any risk of exposure that it will no longer be treated as confidential after that?
Yeah. So trade secret. You got to be really, really careful. Patent applications that get published, so they're in the public domain for the most part. They're before the 18 months, they're still secret. So it's one of these things where you sign contracts with anybody that you want to do business with, and you got to use your gut instinct to see whether it's worth it or not, because you got to take risks at some point, right? That's the whole startup world.
So, but an NDA would be
yes, an NDA on paper, in theory, is protective of it, and I'll go into that just a little bit more in depth. But then again, so there are two things. One is meeting the legal requirement, and the other is, are you going to get scooped because somebody's going to look at it and they're going to breach it? So that's the thing. Yeah. So the getting scooped part, the startup is just going to have to use their gut instinct and the trust and the fifth sense. Now, here's what's really important and is missed quite a bit. Okay, is on the confidentiality agreement. It's called a CDA or an NDA. They say that things communicated between the two parties are to remain confidential. Okay, all good. Now, the thing is, it's confidential for up to 3 years in California and in most states. There is no a forever confidentiality because that's what's required by the courts. 3 years, at max 4 or 5 years. But after that, it's fair games. Okay, both parties can do with whatever they want. Now, the mistake that's made quite a bit is in the NDAs, there's nothing that's mentioned about trade secret. Trade secret, well, if if one is subjected to the NDA where it says 3 years and you can blab about whatever you want, including the trade secret, well, guess what? Your trade secret is out there. Once it's out there and somebody is allowed to speak about it and such, there is no trade secret anymore. So in any NDA, you got to make sure that you have this extra paragraph that talks about trade secret that is a forever thing. So there are two things to it. One is your regular standard vanilla, everyday confidentiality agreement. The other is a trade secret that is a forever thing. And that would be an exception to the required term limit on these things. So that's important there. Now, just circling back to trade secret, saying so doesn't make it so. When you say you have a trade secret, it just doesn't make it a trade secret. You have to do, meaning that you have to actually implement processes that would keep reasonable steps to keep these things trade secret. So if you have a formula, for example, and you have it on a piece of paper, and if you leave it in the middle of the room in your company or for anybody to access and see, that does not meet the requirement for it to qualify as a trade secret. You have to actually build it up and build a process around it to qualify as a trade secret. Because we were involved in a litigation matter where the bad guys, we call them bad guys, when we sue them, the first defense is there was no trade secret. It was there for everybody to see. You can access on the computer. It's there. So then if it's on the computer, you got to create a special access code that only limited number of people that have special access can access it. So you have to qualify for some information in order for it to meet a trade secret. And all of that, if it's an NDA that's going to expire, well, then there is no trade secret anymore.
Wow.
Yeah, no, that's right. And California and other states have statutes specifically defining what a trade secret is and how to maintain it properly.
Well, yes, thank you. So you got to have that NDA properly done, especially if you have trade secrets. So there's a quick question on trade secret, Quan. I think you may have addressed it a little bit. It says, what is the downside of filing secret or unpublished?
The downside, the downside of having a trade secret is that it's hard to keep a trade secret. It's all this bureaucracy that you have around it. And if you're a growing company and if it's a startup, you're going to have people coming in and out. You're going to hire an intern. And sometimes you have to give it to them. Well, we're busy doing the work. Are we going to have to stop every 10 minutes just to ensure quality assurance and all that stuff in the trade secret? It's very burdensome. That's the downside of it.
Well, Coke and the Colonel, they both kept it for a long time, right? So
they have, and they're one of the few successful ones, but for the most part. And the other downside is the trade secret can be reverse engineering. We spoke about that earlier.
Yeah.
And if it's reverse engineer and you don't have an insurance policy on it, there you go. You're at risk, huge risk.
Yeah. Quick question for you, Ken. No, not this one. Is the filing public or public record for the or is it just with stays with the SEC, FinCEN?
So FinCEN is actually Treasury Department.
Treasury. Sorry.
At the moment, there is no public database that anybody can get into to obtain that information. Of course, the laws can always change, but at the moment, it's a completely private filing. The other point that I noticed in the chat is there was a question about this. How do you check the status of it?
Yeah, that's my next question. Yeah,
and the reality is that there isn't a status. It's either filed or not filed. So when you make an electronic filing with FinCEN, you'll get something back from them electronically that confirms that the filing was made. And that's really the only status that you're going to get. But the important point is for investors and for people engaging in M&A transactions, this is a whole new level of due diligence that you need to add to your checklists and to your procedures when you're performing due diligence. Because if you were to invest into or buy a company that hasn't been in compliance, you may be inheriting some very difficult things that you don't want to. And so everybody that's involved in those processes of due diligence need to go back and think about these applications of Corporate Transparency Act filings to that.
Thanks, Ken. And I know Ken has a package for helping others file, so reach out to Ken for any information on that. Kwame, question for you, and that comes up quite a bit. I do see a lot of companies, especially nowadays, talking about mental health, digital mental health. Do they require FDA approval? Is that something that they need to think about?
That's an excellent question. We've worked with several prescription digital therapeutics companies or prescription diagnostic companies that are digital health companies that are used to aid in the diagnosis or treatment of a specific mental health condition. We've worked with an eye tracking software as a medical device company that's used to aid in the diagnosis of PTSD as one example. And we've also worked with companies that are simply managing patient data that goes into other systems that aid in diagnosis. And they were not regulated by the FDA. The former that uses eye tracking, the company is a great company in Austin, Texas called Sensei. They are regulated by the FDA. But the way you can figure out if you're regulated is one, having a clear, crisp, and concise indications for use that talks about whether you're aiding in the diagnosis or treatment of a very specific patient population in a clinical setting that you describe, and you describe the outcomes and or the key features or claims you want to make. From there, you describe the device. Is it AI/ML powered, et cetera? And you describe key outcomes that you're driving. Are you more accurate? What is your accuracy? Do you result in reduced symptoms associated with a particular condition? So those are all the considerations. It's a complex activity to understand how you're regulated, but there's a range of products and conditions. The last thing I'll say, and then I'll pause, is you could also be in a category of what's called a wellness device, where you're not aiding in the diagnosis of cancer. You're aiding in measuring heartbeat, for example, on a watch, and it's an aid for you to live a healthy lifestyle. In those cases, the FDA has intentionally said, we do not want to regulate these products. They are well understood technologies. The safety profile is such that it would be burdensome. Quan was talking about fees. It would be burdensome to take your fees and process these very simple Fitbit and health apps that have a relatively healthy and safe profile. So those are some of the considerations for digital health companies.
Wow. I'll let you ask a question, Quan, next. We just saw a company basically that is similar to Calm, but with biofeedback.
Yes.
So, which is like, it changes what you're looking at depending on your heart rate and your blood pressure and all that. And that's another. And they're basically addressing stress and digital, mental health and all that as well. And so they said they don't require FDA approval, but it sounds like they may not, especially because you just said the blood, measuring your heartbeat doesn't require that, right? So,
but presumably, if it's an implant or an ingested device, it would.
Yeah, that's different.
That's a great point.
Yeah.
So life-saving, life-sustaining devices, generally all implantable devices, the safety profile is such that they would be regulated by the FDA.
Right, yeah.
Absolutely. Quan, you got a question for me, Quan?
I do. So there was a buzz about this some time back, and I lost track of it. So for AI products, you put in the data, and the system learns, and it does what it does. And let's say that you get an FDA approval on that. Now the system is going to continue to learn, and so the output is going to morph and change. How is the FDA accounting for the change of from the delta change from where they approve to now the system is updated and learned, hopefully for the better, that it's no longer the same output as originally before on the FDA approval. How's the FDA dealing with the new output?
That's a great question. The FDA recently promulgated guidance such that a company can, when they have an AI/ML solution, talk about the types of changes that will require a 510K or FDA application. So they proactively say in these scenarios, our software can learn such that this feature may change or this alert may change. And we have already decided that that is going to be the trigger for when we believe a new 510K is required. Having said that, Quan, I'm reminded, and I'll be brief because I know we're getting close to the end. We talked to over 100 medtech companies, and one of the main concern they had about the FDA was lack of guidance for AI/ML solutions. And I have a quote from one of the companies we interviewed. They said there is a gap of knowledge between the FDA's knowledge base and the scope of applications with respect to AI and machine learning. It would be helpful to add AI experts to review teams at the FDA and CMS. And this was in 2022. So what you'll see is a steady drumbeat of guidances for AI/ML solutions to address that, Quan.
Got it. Thanks, Kwame.
Interesting.
Yeah, that is very interesting. Okay, so we got like about 4 minutes left. How about if we do this? How about if we ask each one of you maybe to provide a comment or something to the audience that they should be aware of when it comes to IP legal or FDA, or maybe a recommendation, something they should do. We'll start with Quan.
Sure. So IP is as in many of our other disciplines as well, is a very specialized area. There are plenty of services out there, the LegalZooms of the world, that actually provides for patent drafting, stuff like that. One can actually get a decent patent application in, a provision of patent application in, but one would have to spend a lot of time to make sure you do it right. So some of these foundational stuff, and I would consider corporate law and FDA, if you're in the health area, to be the foundational stuff. If you don't get it right at the very beginning, the consequences and the problems that you get from not doing it right at the beginning could be catastrophic towards the end there. So weigh the considerations very thoughtfully, as to see whether you want to do something by yourself along the line. And money is important, I understand, but if you're going to do it by yourself, make sure you spend the time to read through what the requirements are for patent filing. So that would be my message.
Yeah.
Okay, go ahead, Ken.
So, one of the things that I've seen as a trap for startup companies in the ecosystem is, they're always looking for capital. And one of the venues for capital are grants that come either from universities or from government agencies. And a lot of times they don't realize that if they apply a particular grant funding to the development of intellectual property, there may be contractually or by law, there may be some ability of that granting agency to claim an interest in the IP that the people receiving the grant just aren't aware of. It's often a small print line in a grant application or a granting letter. Sometimes it comes up in royalty agreements. For example, in cooperative research and development agreements that you may enter into with a university. But you really need to make sure that you're not encumbering your intellectual property unwittingly by accepting a cash grant from a location.
That's very interesting. Kwame, you're last but not least.
I would say, having evaluated 1,000 FDA applications personally and worked with 50 companies in my practice, the number one question is it too early for me to get a regulatory strategy in place? And 90% of the time, it is not too early. You really just need a simple set of pieces of information to get a minimal regulatory strategy in place. And I would just encourage companies to start thinking about it earlier rather than later. And there are plenty of professionals that can help you along that way.
Well, thank you all very much. I thought this was an excellent conversation here. We talked about a lot of subjects, from IP to FDA to legal, corporate legal. Thank you so much for being here. Thanks for everyone for joining us. You can always review this video on LinkedIn Live or LinkedIn, the same link. And if you have any questions for us, we have our emails. Kwame, do you want to put your email in the chat if you can? If you want anyone to reach out to you, please reach out to Kwame for any FDA and Quan and his email is right on the screen. Of course, Ken as well. And me too. I didn't get any questions. You didn't ask me any questions, Quan, so that's okay.
Yeah, actually, I was going to say at the beginning there, I usually hear you tell the audience of what it is that you do for the startup world, and you do a lot. Really appreciate it, JJ. I mean, this is important. It's it takes a village to raise a company. So, could you share with the audience what you do for startups out there?
Thanks. Sure. Yes. I appreciate the question. So we help startups with their startup journey. What does that mean? It's really complex to start a company, raise capital, grow a company, hire people, having the right team, reaching the right investors. So these are all part of that journey. So what we do is we help the startups with their entire journey from beginning of maybe having an idea to really creating an MVP or a product or a service, to crafting their story, to putting their pitch deck together, to tell the story to the investors, to help them with their due diligence process, not legal due diligence like Ken does, but more the other due diligence related stuff like asking, when you go into due diligence with an angel group or investors, it's not an easy thing, and you could immediately lose, have the investors lose interest. So, anyways, these are the areas that we help them with, and then we help them. We introduce them to investors as well, so they could raise capital, and also we do invest in them as well as part of what we do. So it is a kind of an overall. Not every company we work with, we invest in, but also we invest in companies that we don't work with either. So it's all around. So I hope that helps. All right.
Excellent.
Okay. Thank you so much, everyone, and we'll see you again. And you guys stay on, and we'll talk for a couple of seconds after we turn off the live stream. Thank you all very much, and join us. We're going to do this again every month. So usually it's the second Tuesday of the month. And then one last thing is we have a new live events, virtual events coming up, and also we have some in-person events coming up. Keep your eye on LinkedIn. Bye, everyone.